Hello, I'm Cliff Ely. I'm an attorney in Colorado, and I limit my practice to representing injured workers in workers' compensation cases. Today I'm going to talk about permanent total disability benefits. In other videos I've discussed permanent partial disability benefits, and those benefits are permanent disability benefits paid when someone is injured on the job, has permanent impairment, but is able to return to work at some type of employment. Now, the fact that somebody isn't able to return to work at their old job doesn't affect the amount of permanent partial disability benefits that they're entitled to. And that's often seen as a very unfair part of the Workers' Compensation Act. If someone's working for $20 an hour and is able to return to work at a minimum wage job, but not their old job because of their restrictions, they're limited to permanent partial disability benefits. However, if you're unable to return to work at any type of employment, you're entitled to permanent total disability benefits. In order to receive permanent total disability benefits, you have to be found to be unable to make any wages whatsoever. The definition of permanent total disability benefits is found in the Colorado Workers' Compensation Act at 8420116.5a, and it states permanent total disability means the employee is unable to earn any wages in the same or other employment. Any wages is considered any wages. If you can only work a few hours a day, you're still making some wages. And the same or other employment means that if you can return to work at your old job for a few hours or work at any other job and make some wages there, you're not permanently totally disabled. This definition of permanent total disability benefits creates a very difficult burden for an injured worker to meet. An injured worker has to prove that he's unable to return to any work whatsoever, if only for a few hours a day, and it doesn't matter if the work that he is found to be able to perform would not be enough to support himself or his family and put him into bankruptcy. If they can make any wages whatsoever, they're not permanently totally disabled. And it is the claimant's burden to prove that he's permanently totally disabled. The administrative law judge has broad discretion in deciding if someone can return to work and earn any wages or not. Usually, both sides in a workers' compensation case use vocational rehabilitation experts to give an opinion on whether the claimant is employable. Both sides' vocational experts will look at the claimant's education, work experience, age, and restrictions and other factors in determining whether or not the claimant can find employment. The respondent's vocational rehabilitation expert usually issues a report in which the expert lists numerous jobs that the claimant is able to perform, and therefore the vocational rehabilitation expert concludes that the claimant is not permanently totally disabled. The best way to combat that opinion is for the claimant to look for work in those areas and to keep a record of the places they've applied to and the responses they've received. This can be very difficult because frequently the claimant is very disabled. It is apparent to a potential employer when the claimant applies for a job that the claimant has severe restrictions. Often it's unlikely that this employer would hire the claimant when there are able-bodied workers applying for work every day at that employment. Still, this is something that should be done by a claimant in order to increase the chances of the administrative law judge finding the claimant to be permanently totally disabled. It's one of the best ways to combat the respondent's vocational rehabilitation expert's opinion that the claimant can work. Sometimes the pre-injury employer will offer work to the claimant, and this is often work that the employer doesn't need to have done and wouldn't hire anyone to do. Usually this is called sheltered employment, and it's typified by the kind of work that is make work and that would not be around for the claimant if he hadn't been injured on the job. It's just being offered to prevent the judge from finding that the claimant is permanently totally disabled. This does not prevent the judge from finding the claimant is permanently totally disabled. The administrative law judge can find that this is sheltered make work and is only being offered to prevent the claimant from being permanently totally disabled. An insurance company can offer vocational rehabilitation services to an injured worker to try to help them find work. This is usually done to prevent a finding that the claimant is permanently totally disabled. If a claimant refuses these kind of services, the judge can determine based on that the claimant is not permanently totally disabled. So it is usually in the injured worker's best interest to accept vocational rehabilitation services and allow the insurance company to assist him in trying to find work. Also, most people feel that it's better to work than not work, so if the vocational rehabilitation services result in an injured worker being able to find work, then that's probably a very good outcome for that injured worker. Usually, the insurance company cannot require the claimant to move several hundred miles for some job, perhaps in Kansas City. The administrative law judge has discretion, but usually the work must be a commutable distance from the claimant's home. If the worker is found to be permanently totally disabled, he's entitled to 2/3 of his wages for the rest of his life, and can also receive a lump sum of those benefits of $60,000. There are certain offsets that are applied to permanent total disability benefits, which I'll discuss in a future video. However, if you've been injured on the job and are worried that you are permanently totally disabled, please give me a call and I'd be happy to discuss this with you in a free consultation. My number is 303-785-2828.